Hello, everybody, and welcome back to the Law Academy, focusing on the subject of land law in this lesson. We're going to move on to topic number 6 in this video. This video beginning an introduction to the subject of leases. We're going to take an introduction, like I said, to what leases are in this video, the distinguish between a lease and a license in this lesson as well, before talking about the essential characteristics of a lease in the next video, which is, of course, the subject of the case of Street and Mountford. So, fundamentally, topic 6 concerns ourselves with the subject of leases, the leasehold estate. We'll talk about what a lease is, the different types of lease that exist, as well as some of the key questions relating to the bringing of a lease to an end, as well as the issue of forfeiture of leases, which is often one of the larger topics that are often cited in exam questions when it comes to the topic on land law. We will then move on in topic 7 to looking at licenses and proprietary estoppel. Topic 8 will look at easements. Topic 9 will look at freehold covenants. And then topic 10 will look at mortgages. So, leases, or sometimes described as the leasehold estate, which is of course the distinction between a leasehold and a freehold, is a legal estate which is registered under Section 1 of the 1925 Law of Property Act. It is one of the legal estates that is cited as per Section 1 of the 1925 Act, and of course is something that is that exists as quite a substantive legal right in conjunction with that of the freehold estate, with the fee simple. The leasehold estate differs from the freehold estate in the sense that when we think about the freehold, there will be an entitlement to property for essentially an indefinite amount of time, to essentially represent what would be described as a near complete ownership of the property, despite the fact that, of course, by technicalities and in technicalities, you do not technically own land in England and Wales. You own estates in land, and that all land is owned by the Crown. If you have access to and you have ownership over a freehold estate, then you essentially have the entitlement to that property, and it's an indefinite entitlement to that property. However, when it comes to a leasehold estate, when it comes to the lease, the time period in which you have access to that property is actually one of the key determinative delineations that is made. You often will think about the delineations that are made between leases and other types of interest in land in terms of the duration, in terms of the time period in which that lease is actually available for. That is what determines and delineates, should I say, the distinction between the leasehold and the freehold. You can then make a distinction between a lease and an easement, or any other kind of interest of that kind of nature, as well as a distinction between a lease and a license. The distinction there being, of course, one is a legal estate, one is only a proprietary, a personal right. So, the leasehold estate entitles an owner to have an exclusive possession of the property for the duration of time that is specified in the lease itself. So, where we are talking about what kind of rights you essentially have almost all of the rights of a freehold owner for a specific duration of time. It is the time difference that is what delineates the leasehold from the freehold. Now, the lease agreement, of course, determines the type of lease that we are going to be agreeing upon. It also determines the length of time in which the lease will last. Some leases last for a year, some last for 100 years, some last for 999 years, which is quite an interesting understanding of the technicalities of land law in relation to leases. Now, I want to just finish this introductory lesson by talking about a case from 2000, the case of Bruton versus London and Quadrant Housing Trust Limited. This case, the claimant sought to have his agreement made with a trust owning property to be recognised as a lease rather than merely a licence. The reason why you might want to do so is because when you recognize something as a lease, if something is determined to have been a lease, it grants the leasehold owner more rights over the property, more proprietary rights, in fact, than a mere license holder. Licenses are not particularly very strong in terms of the rights that they ascribe to the person who holds the license. The reason for this was, if it was to be considered a lease, the defendant in question would have to have the upholding of their statutory duty to repair some parts of the property. This is part of Section 11 of the Landlord and Tenant Act from 1985. So basically, you have a claimant who has a property, who has a certain amount of control or ownership over a property, and the defendant, the landlord or the alleged landlord, should have made a number of repairs. If it was only a license, then this repair duty is not a statutory duty. It is not part of the Landlord and Tenant Act. However, if it is a lease, then they will be required, as part of the Landlord and Tenant Act, to uphold their obligations as a landlord to be able to make a number of repairs with regard to some parts of the property. In reality, the trust owning the property did not have the statutory duty to grant leases. In fact, they only had the authority to grant licenses. And so really the first initial question that you should think about is the maxim in law that you can't give what you don't have. So essentially, if you do not have the authority to grant a lease, then how can it be anything more than a license? It has to have only been a lease, which therefore would represent quite a simple conclusion to this case. It would represent a conclusion to this case that is in line with the basic principles in law that you can't give what you don't have, and so as a result of which, if you do not have the authority, the power, the ability to create a lease, how could you create a lease? Is essentially the question that is asked by the court. In addition to this, in addition to the statutory power that the trust owning the property had only to grant licenses but not to grant leases, the agreement in question was very clear that it was intending to grant a license and not a lease. This is something that we will get to at various points throughout this series of lessons. The extent to which an agreement which is, by all accounts, described as or intended to be a license, the extent to which that actually protects individuals against claims that in fact it is not a license, it is in fact a lease. Because in some circumstances we find that even though the agreement is called a license agreement, and even though it says this is a license, if by all accounts it represents the rights that are ascribed to an individual who has a leasehold, essentially if it acts like a lease, even if it is called a license, the courts will find a lease in those circumstances. The Court of Appeal essentially rejected the claimant's argument, owing to the lack of intention to create a lease, in addition to these numerous other factors. So not only there was no intention to create a lease on the one hand, but there was also no authority on the part of the trust that owned the property to be able to even grant a lease. It could only grant licenses, and it was intended to grant a license, so it could only have been a license. However, the House of Lords overturned this ruling. Instead, they held that this was indeed a lease. And because it was a lease, it fell into the scope of Section 11 of the Landlord and Tenant Act of 1985, and as a result of this meant that the defendant would have a statutory duty to make a number of repairs in regards to the property. This is a very controversial case, because what this does is it seems to strike against one of the most foundational principles of law in general, which is this idea that you cannot give what you do not have. If you don't have the authority and the ability to grant licenses, how can you grant leases? How can you grant something that is then therefore a lease? It seems silly to do. It is also one that seems to strike against the intentions of the party in the creation of a lease or a license in this regard. What it essentially tells us, however, is that an intention to create a license and all of the factors which are considered here, like the name of the agreement being a license agreement versus a lease agreement, okay, all of these factors do not necessarily negate the characteristics of the right that the person who is the claimant that they may have as a leasehold. So even, like I said, even if it is called a license agreement, if it has all of the characteristics of a lease, it will be found on the basis of the facts to have been a lease rather than a license. This is one of those interesting quirks within land law that we're going to get to in future lessons' time.